So now we basically concluded the part of the day where we had original papers being presented, and we're going back to sort of the more general discussions that we started the day with on empirical constitutional studies, or whatever we mean by empirical constitutional studies, maybe, or measuring impact in constitutional law. And we have a number of great panelists for that, and hopefully the papers that we discussed allow us to come back to some of those questions as well. So let me see, Richard Albert is first, I think. And I'm assuming he's no longer running. No.
Hello, that's a reference, for those of you who are just joining us, that's a reference to this morning when we were going around introducing ourselves. And I just come back from a run and was getting out of the shower, but was logged on, but not without my camera. But here I am. And I just want to begin by saying thank you to Adam and Mila for this invitation. I'm going to share my screen, actually, if I could. And I'll just preface it by saying that I'm going to use this time not to talk about the book, because I'm on a panel in November on the book at the Mexican Supreme Court. And so I'm going to reserve my remarks for that program. But it's an amazing, amazing book, as you know. I have it. I don't know if you can see me. I'm just going to begin the slideshow, but I don't know if you can see me, but I have the book here with me. And I did put in the chat that in addition to a mug, it'd be great to have a signed copy of the book, a second copy for those of us who already have a first copy, because OUP can certainly afford it. But wonderful. Congratulations again to Adam and Mila on the book. I read it this spring as I was doing some other things. I'm the book reviews editor at the American Journal of Comparative Law, and I got a copy of this manuscript, and I was very happy to commission a review of the book by Stephen Gardbaum, and that should be coming out relatively soon. But as I was reading the book, I was thinking, well, this is a great duo, Adam and Mila and Adam, a really terrific duo. So I started to think about other terrific duos out there in the world, and here are some others. But of course, given that the theme of today is Mila and Adam and Mila, I thought I'd replace those two with these two. Adam, my apologies, because I know Chicago is where you are right now, and we have to put the Bulls to the side. I want to say, before I talk about my own ideas, this to me comes at a wonderful time, this gathering, because I have a leave next year, the academic year 21-22, and I'm thinking about some new projects. So I'm going to put on the table some suggestions of things that I'm thinking about doing, and it's really a request for feedback and help, whether you think these are good things to pursue. You guys are partly my audience. As Sandy described himself, I'm a consumer of this. So if this will be my effort to dip my toe in this field, I'd love for it to be relevant and of interest to you. So I'll ask for your feedback on 3 ideas that I have. But first, I want to just say a special congratulations to Mila, because we're going to honor Mila at our global summit in January. We'll be giving Mila one of our 4 prizes as an innovator, largely for her work in this field, and she'll be recognized alongside 3 others. Perhaps you know the others, Erin Delaney and Magdalena Correa and Bertil Oder, each for a great contribution each has made to the study of constitutionalism. So congratulations, Mila. Before I begin, just 2 more things. One is I'm a co-editor of a book series at Oxford on comparative constitutionalism. And here are the books on the left that we've published so far. And on the right, you'll see the books that are coming out. And this is really an invitation to all of you to submit books proposals for our new series. I'm hoping to twist Zach Elkins' arm into giving us his book. He's working on a great book right now. But we're open and excited about this work. Ron just published his latest book with us, and we have some others that are really excited. We're really excited about. So please do keep us in mind if you'd like to publish a book with us at OUP. And the last thing I'll mention before I move on to my own ideas, and I know I'm taking up a lot of time, but my interest in this set of conversations is not new. Back in 2015, the president of the American Society of Comparative Law asked me to chair a committee that sought to ask questions, including how to better integrate social sciences into the study of comparative law. We generated a report in 2016, and on the conference report committee, or rather the report committee, there are many people in this room. Tom Ginsberg, of course, Mila, Versteeg, Katerina, Linos, and Ron. I don't know if Ron is still here. He was here this morning. But the report, I think, was about 30 pages or so, no, 22 pages or so. I'm happy to share that with you if anybody is interested. Okay. So my leave for a year, next year in the fall, one thing that interests me quite generally is how constitutions change. And I'm interested specifically in how we amend constitutions. And in the narrow category of amendment, there's a question that interests me perhaps more than all others, which is the phenomenon of unamendable provisions, unamendable provisions. And here are two different kinds of unamendable rules that you see in constitutions. One you might call closed. And here I'm going to draw from Turkey. The state of Turkey's flag is unamendable. That was Sandy. I recognize the laugh. And the second kind of rule that I see in the world is what you can call perhaps an open rule. And here I want to draw from the Czech Republic. Basically, democracy is unamendable. The essential characteristics or requirements for a democratic state are unamendable. These are two very different kinds of unamendability, aren't they? And so I'm interested in figuring out how the second is interpreted variously by political actors who are responsible for determining its meaning and for actually applying it against certain amendments that are thought to be unconstitutional. The Czech Republic Constitutional Court invalidated an amendment on grounds of this particular unamendable rule. I'm interested in doing some survey analysis with constitutional and Supreme Court justices to understand how they interpret these things, these open rules that make things unamendable. So that's one possible study that I'm interested in engaging in. The second set of interests that I have deal with political behavior, constitutional conventions, in other words, or if you prefer, unwritten constitutional norms. And I begin with Sir Ivor Jennings, who has a three-part test to identify conventions. There must be precedents, either positive or negative, but just one is sufficient in his view. There is a felt obligation on the part of political actors to conform their conduct to those precedents. And then third, there must be some democracy regarding or governance regarding reason for the existence of this practice that, if all three criteria are met, matures into a norm, a constitution level norm. And in Canada, we have a number of practices, or rather negative precedents of practices you can call as well. And I'm wondering whether they've matured into conventions. And so I'm going to be interested in speaking with political actors about how and why they do feel compelled or constrained in the exercise of their powers in relation to three powers. One, we have a power that people refer to as the notwithstanding power. I refer to it as the legislative suspension power. It says that Parliament or the provincial assemblies can pass a law that suspends the coming into force of a judgment of the court on its interpretation of a certain category of rights. So it really is a veto power that legislative assemblies can exercise when they wish. Now, the power has been used by provincial assemblies, but never, ever, ever in 38 years by the Parliament of Canada. And there's an argument that there is a convention that has been formed, or it is in formation, pursuant to which this power cannot be exercised. I want to find out why that is, and if in fact political actors believe this is the case. Similarly, there's a twin set of powers that we refer to as the disallowance and reservation powers that give the Parliament of Canada the power either press pause on a law being passed in a province, or to actually repeal a law that has been duly passed by a province. Neither of these powers has been used in decades. And there's an argument that there's a conventional understanding that these are no longer usable, that they have fallen into desuetude, desuetude, of course, entails a kind of a toxicity. I want to find out if that's true, again, with some surveys and discussions with political actors. I don't know if this is of interest to you. It's of interest to me, but I'd like it to be useful. And then finally, 3, there's an argument that there is now a convention of a national referendum when amendments of a national scope are passed in Canada, because in 1992, a referendum was used, even though there is no mention of a referendum requirement in the codified rules of amendment in the Constitution. So this would be the argument that there's a conventional expectation that we must now use a referendum when the Constitution is amended in Canada. I say we because I'm Canadian. Finally, in just 30 seconds. Finally, the third thing I'm thinking about is doing something about measuring amendment difficulty. Now, there are many sophisticated studies, more than the Lutz study, which is represented on the left. Mila and Emily have done stuff on this. Tom and James have done stuff on this. But I think there are more questions to be asked if we are to measure amendment difficulty, relative difficulty of one constitution to another. Because the studies that have already been published don't account in a number of ways for alternative amendment procedures. South Africa's constitution has 3 procedures to amend. Canada's has 5. Nigeria has 2. How does that factor into amendment difficulty? There's also a temporal variability. In the 19-teens, as you may recall, there were about 4 amendments in the span of 7 years in the US. People thought the US Constitution then was too easy to amend. And yet, of course, Article 5 remains the same then as it is now. And today it's impossible, people say, to amend. So that must be factored into amendment difficulty. There's also unamendability. The constitutions of India, for example, and Colombia, for example, make no statement about anything being unamendable. And yet the court has created these doctrines, the basic structure in India, the substitution in Colombia, that make it hard to amend the Constitution in certain cases. But this, of course, is not reflected in the codified rules of change. So how does that factor into how we measure amendment difficulty? It's very difficult to do that. And then finally, this I think is the most vexing complication in how we measure amendment difficulty, is that if you look at the text of amendment rules and constitutions, that won't tell you all you need to know. Because sometimes there have been modifications made to the rules themselves, either in statutes, either in the practices that political actors engage in connection with the use of these rules, that either makes the rules harder to use or easier to use. So this, to me, is the holy grail in the study of constitutional amendment, to figure out really the relative amendment difficulty of one constitution versus the next. And if you can do it from multiple constitutions, then that's really amazing. So I want to think about whether this is possible. My guess is that it's going to be very difficult to do. I couldn't do it. I don't have the tools, but I want to think about what would be needed to do this well. I'm going to close now, Adam and Mila and Adam, but I do want to just stress that if there's one thing you remember from this 10-minute presentation, I want you to remember this. Among the best duos out there. Congratulations once again on the book. Thanks for having me.
Thanks a lot, Richard, for a lot of difficult questions, and hopefully we'll have time to get to those challenging empirical questions. Okay, I guess Mark Graber is next.
I would like to make 4 points. Now, people who know me know I'm very fond of Strunk and White, and Strunk and White would say there are some wasted words here. I should just say, I will make 4 points. This is like people normally begin, I will be brief. If you wanted to be brief, you would skip the sentence. I will be brief. But it's been a very, very long conference. And the truth is, I would like to make 4 points, but whether I will actually successfully make them is unclear. Point number 1, thank you very, very much, Adam and Mila. This has really been a terrific conference, and bringing together people who, some of whom speak to each other constantly, some of whom don't, some of I just met and realized we need to be in conversation. And that's what a really good conference is about. Problem or point number 2, I told you it was going to be hard to make them. Point number 2 is to problematize what we mean by empirical legal studies. Now, in one sense, empirical legal studies could become political behavior and political science. There's a sense in which all of political science studies political behavior. There's nothing else to study, but we all know it's a code word for a certain kind of school. So in one sense, empirical legal studies is a code word for Lee Epstein. If Lee Epstein is interested in it, it's empirical legal studies. If she's not, it isn't. And we all know what that means. But as we open the tent, we get into problems as to where the tent doesn't end and what isn't included. So consider the following problems. We all know that one problem with normative legal studies is inevitably the empirical is thrown in. So Netta's paper, I think, was really good on highlighting that people who engage in constitutional interpretation about wedding cakes and exemptions were throwing in empirical assumptions right and left and never testing them. But I think one thing today proved is it turns out what we do when we do empirical legal studies is we throw in normative assumptions right and left and often don't fully explore them. So in fact, what is an unlawful suspension of the Constitution? What is women's equality? What is a legitimate restriction? And part of it is that law inevitably requires us to examine essentially contested concepts whose definitions inevitably include some norms. And what we can say is, and this is why the importance of this conference is in fact, we're not working on distinct problems. We're all working on problems that have empirical and normative dimensions that we can't fully disaggregate, that require a wide variety of tools. And in fact, with all of us putting different tools to help enlighten us. But I would urge us to think of the field in that way, and rather, this is empirical legal studies, this is something else. To the extent there's a commonality, let me suggest what may be a friendly amendment to Rand's claim that we should look at comparative constitutional studies rather than simply comparative constitutional law. And that is, we are all concerned with how constitutions work. How they are interpreted is a subset of how they work, but we are involved in constitutional politics rather than constitutional law. We are asking what people are doing when they make constitutions, when they interpret constitutions, when they implement constitutions, and what the impact of what they're doing is, rather than simply what their words mean. So when we say the most common sentence in American constitutional English, Marbury established judicial review, we have to, what do we mean by established? What did Marbury do? Now, we can't understand what Marbury did unless we understand the meaning of the words. But understanding the meaning of the words is only part of it. And by focusing on how Marbury works, what constitutions do, we understand ourselves as engaged in a product in which the empirical and normative have equal purchase, rather than as a primarily empirical project that, has little normative things on the side, or a normative project that, has a little empirical things. And I think one of the things we've done, and the book does this marvelously, is suggest that one of the things constitutions don't do is constrain, or they don't do well, is constrain. That if the point of constitutional rights, if we think what people are doing when they put constitutional rights in a constitution is telling what we'll call unsympathetic constitutional decision makers, you have to do X even though you want to do Y, it's going to fail. And it's going to fail because, as Mia and Adam point out, and Jerry Rosenberg and others, there are just too many ways of getting around constitutional rights. But let me suggest an alternative. Rather than thinking of constitutional rights as constraints, thinking of them as empowerments. And in fact, in collapsing the distinction between normative and empirical, I want to collapse the distinction between constitutional rights and constitutional powers. What a constitutional right does is it empowers somebody, could be a Supreme Court justice, could be a national legislature, to constrain somebody else. What a power does, the same thing. It empowers some people to constrain others. The constitutional right of free speech empowers the Supreme Court to constrain people who disagree with the Supreme Court's understanding of free speech. And I think we get more purchase. So consider two kinds of models. First, I want to call the 1865 model slavery. Slavery did not become abolished because one day slaveholders said, you know, we really like slavery. Darn that 13th Amendment. Slavery was abolished for several reasons. First, the people who said we really like slavery were slaughtered. It's a very effective way of getting your way. The second is the people who had the guns passed the 13th Amendment. They empowered Congress, a Congress that supported, at least in a certain sense, the right not to be a slave. So rather than thinking of the 13th Amendment as working because constraining people, the 13th Amendment worked because it gave members of Congress who in 1860 did not think they had the power to abolish slavery, to pass civil rights law. It gave them the power. Second version is the Constitution of 1868. And it's a version of what Rand wrote in his first book. And that is what a constitution does is it first creates powers and then creates a transfer of powers or reconstructs the government so that the sympathetic exercise the power. So you think your friends are in the judiciary, you create new rights, and you make them judicially enforceable. Again, they're not working as constraints on the judiciary. They're empowering Aaron Barak to do what Aaron Barak wants to do. The argument I have in the 14th Amendment book is Section 1 of the 14th Amendment was meaningless. And Republicans knew it was meaningless. Section 2 was designed to ensure the Republican Party controlled the national government and could enforce the rights of the 13th Amendment on hostile states. Now, notice what I've done here. Little history, a little empirics, a little norm. That's what I think constitutional politics and what we might call the study of constitutional studies is about. We all have little pieces. We can all learn from each other, but we shouldn't think our little pieces are an island separated from the rest. Thank you.
Great. Thank you so much, Mark. Many thanks for discussion on the table here. But I want to move on and see Yvonne, you're next.
Great. Well, first off, thank you so much. I join everyone thanking Mila and Adam, obviously for the book, but also for this colloquium. I've appreciated listening to so many of these fascinating conversations, even though I've had to go in and out because due to the pandemic, it is also Georgetown's faculty workshop on Fridays now. So still, it has been great to be able to have been part of this and to hear from all of you. And so on the book, congratulations, both of you, on what an incredibly important and topical subject, whether and how constitutional rights matter. Certainly one of the most sort of relevant topics we can think about now, and also how hugely ambitious the project is, both conceptually and methodologically, right? So like I am deeply impressed and in awe of the amount of work and ambition that went into this, and the wide-ranging use of empirical methods. I very much appreciated the philosophy that you all spoke about in the introduction of not letting the perfect be the enemy of the good, and going ahead with an impressive use of all these several empirical methods, surveys, statistical analysis, and case studies. So on that, and more broadly on empirical methods in comparative constitutional law, as someone who doesn't do quantitative methods at all, I deeply appreciated the range of methods that both of you use, especially the case studies method, right? So like for many of us outside of the political science field, there's been this idea that the dominant methodologies in the field tend to be quantitative, large N case studies, etc. And so it's refreshing and heartening to see Mila and Adam use so many different methods, including these detailed case studies. Although I know there was debate and this discussion earlier today by Mark and others, or both Marks, Tushnet and Graeber, on the on what counts as case studies, historical case studies, etc. What I consider empirical. But one of the things I think we should all applaud in Mila and Adam's work is that they combine impressive quantitative work with really sophisticated and nuanced qualitative methods as well. So having said all of that, and my appreciation for the huge amount of ambition and work that this project shows, I wanted to raise some questions about the actual case studies they selected, speaking about case studies, and the payoffs of trying to measure the outcomes of constitutional provisions. And so in line with my own methodological as well as substantive interests, I will focus on religion as a case study in their chapter on religious freedom to raise some of the questions I have more broadly about the type of methodology used in this book. So Mila and Adam have this fascinating chapter and case study on using religious freedom as an example of an organizational right, using Russia as the central case study. And this raised a couple of questions for me that relate to broader methodological questions. The first two are probably conceptual, and then that's the third and fourth on the more empirical. So first, on the conceptual point, what counts in measuring religious freedom and who does it count for? Right? I mean, would this be the religious freedom of the religious organizations or groups? What about the individuals within those groups? What about individuals who wish to leave those groups? And what happens when the religious freedom of the organization is in tension with the religious freedom of an individual member of the group who may wish to exit the group? And I'm thinking here, for example, about apostasy type cases, which is the fault line in a lot of pluralistic legal systems or Muslim majority states. And in those kind of contexts, the religious group or organization itself that may play a key role in deciding the entries and exits into the group, right? And if an individual, for example, converts out of that religion of Islam, wishes to exit of the group, does not wish to go through the religious group's procedures for doing so, and then the group claims that their religious autonomy or liberty of the group must mean that the individual has to go through the proper system, for example, the Sharia court system, then would this be coded as undermining the religious freedom of the individual or undermining the religious freedom of the group? And which seem to be somewhat in tension with each other. Because in a context like that, the interpretation of, as you all rightly point out, the right to profess and practice the religion, somewhere in the Malaysian constitution, for example, the right to profess and practice the religion, the way that's coded by the state and the courts and the group would be that it is not undermining of the right of an individual to profess and practice his or her religion if they're professing and practicing the procedures of that religion to exit that religion, right? It was not actually seen as a religious freedom violation. So that was one sort of tension that intrigued me. And then second, on the conceptual point of religious freedom as an organizational right writ large, as has come up in a couple of the discussions, I mean, one reason why religion plays such a key role in so many constitutions is it is about deep affiliations or identity within a group, and the group here is often much more than just an organization. It's about identity. It's about ethnicity. It's about nationalism. It's about so many things, right? And so a group that has a stake in mobilizing itself for religious freedom may not be because of religion per se, but because of its wish to protect ethnic nationalist supremacy. I mean, that's that might drive the supremacy of a particular religious ethnic group in a particular context. And that could drive also a liberal populism and nationalism. So I wondered what you thought about this connection between an organization's mobilization or protection of a constitutional right that may have a negative effects for constitutional democracy overall. Third, how much can constitutional text tell you about the relationship? Well, how much can constitutional text tell you in general, methodologically, that's a question, but in this context, take, for example, the relationship between an official religion and religious freedom, right? What is the relationship between the role of a constitution that has a state religion and religious freedom? And you say, kind of intriguingly, that an official state religion is associated with lower levels of religious freedom de facto. And I wondered what this very definition of official religion. Well, first, that's our privileges and interpretive view of religion and rights, right? Because something has to be in the constitutional text for it to be measured to begin with. And then second, I wondered about the de jure versus de facto distinction between what kinds of religions are in this official religion. For instance, the distinction between one that might have a more expressive or symbolic function versus those that are explicitly meant to function so that the constitution has a theocratic basis. So for instance, the difference between the place of religion in an explicitly theocratic constitution like those in some Middle Eastern contexts versus an official religion, but a weak form of official religion in some European countries like the church in Norway, Finland, Iceland, which is, arguably some of Europe's more liberal polities. Although with Rand Herschel somewhere in the room, I won't go into this much more, but Rand's own spectrum of various different types of the role of religion, and showing really that the textual role of religion itself tells us very little, right? It tells us very little. It's really how that constitutional context interprets that or practices that. And then there's also a temporal element to that on top of all of that, which is that constitutions change, or rather the informal constitutional change. There may be different official religion that was meant to have a symbolic function, purely symbolic function, and then gets politically manipulated to have a much more substantive role in the constitution over time, even though the formal text doesn't change at all. So head nod here to Richard Albert and his questions on informal constitutional amendment. And then finally, and this is just a small point, but I'm curious on the case study selection itself, like why Russia as a chosen case study for religion, right? Is it because Russia is a hard case, or is it an easy case? Why is it an exemplary case for as case study of religious liberty? And I read both as the religious research methods part to try to track the variables for why, for example, Russia might be picked, and as well as the description in the chapter itself, and it still sort of was not entirely clear to me, like what the variables here that would suggest that Russia, is a sort of the epitome for this type of case study on religious freedom. And also, you mentioned Indonesia as well in your chapter, and I think that is a particularly interesting because it has the combination of being in a pluralistic, diverse society, which had maybe some commitment to different types of religious freedom and different official religions, and then that shift, right? But I was wondering, Russia is interesting, but has a lot of conditions that seem to create a lot of noise, the sort of authoritarianism, the lack of a lot of religious pluralism, the fact that the religious revival itself, as you all acknowledge in the chapter, seems to be more about visibility, right? These religious groups had operated underground before. It's just that, and that particular opening may have then just become more visible rather than an actual revival itself. But after all of that, the takeaway is this was fascinating and exciting and ambitious and a really wonderful project. And I'm, as always, deeply excited and in awe of the work that all of you do. So thank you for the chance to comment and to engage with this wonderful work.
Thank you so much, Yvonne. You put so many things on the table. We really should have a longer, more detailed conversation about some of these issues. And obviously religion is very complex. Anyways, I should constrain myself because I'm moderating. It's a big tension throughout the day. But I guess the next person to speak is Alex. Alex?
I'm just trying to share my screen. Just a moment.
Okay. Sorry for my.
You know. Now I need to go into presentation mode. Do you see me in the presentation mode, or do you see it?
Yes, we see the presentation, Alex.
You see the presentation. Very good. Okay, so thank you very much for the invitation. So I'm coming here as somebody who came to this subject that we presented in the other experiment, inspired by some of the work that that Mila had been doing, and so I wanted to share a couple of methodological thoughts with you about what I think could be the value of experiments in constitutional law. And of course, given that I'm not mainly a constitutional lawyer, I'm very interested to solicit also your feedback on that. So please use the chat or send me emails so that I can update this kind of view. So to just get an overview of scholarship in constitutional law, I did a quick and dirty search on Hein Online, looking at law articles in constitutional law, and I found that about 50% of constitutional law scholarship is purely doctrinal and theoretical. That fell from 60% to about 50%, and 45% is empirical. But most of the empirical research is empirical research in the sense that Mark Tusnet reminded us not to forget, and only a tiny little sliver is quantitative empirical research. And this is, of course, what Mila's and Adam's book is about. But who knows, the book might stimulate a search in that line of research, and we can treat the publication as an idea for an event study. But so far, it's this tiny little sliver that you see in yellow. Then what I also looked at is at the percentage of different quantitative methods over time. And you see that there's a relatively big area that I probably still need to refine, that I wasn't able to really classify. But I think what's important is the bottom of the graph, where you still see that actually papers that try to identify causation, and that would be papers that do causal inference, but also experimental papers have been on the rise. So they went from about 10% of the quantitative papers to about 20%. Now, within the experiment, what you can see is that almost all is vignette study, or survey experiments, as Mila and Adam call them in their book. And those would be papers like the one presented by Kevin and Charles, and most experimental studies in Adam's and Mila's book. The green area is papers like Netter's, and the red area is what Adi and I have presented, and that is about less than a paper per year in this sample of American law reviews. And I'm sure many of you are also very skeptical that anything useful can be learned from abstract lab experiments to answer questions relevant to constitutional law. After all, lab experiments are best at identifying regularities in individual human behavior, but often things we are interested in are the result of collective action. And moreover, human decision is embedded in institutions, and these institutions interact and frame human decision-making. And this is particularly relevant in the area of constitutional law, where institutions tend to be thick and important. So in some way, we're facing the daunting task here of defending the value of a methodology in constitutional law that's virtually non-existent, and against which very good arguments can be raised. So kind of the first thought that I have on this is, yes, but sometimes we have individual decisions also in constitutional context. We have police officers on the ground who decide whether to torture or not. We have supervisors deciding on whether to turn a blind eye or to take a violation seriously. And of course, there's also an old methodological discussion in economics where you know, there's this idea that yes, we are often interested in social phenomena that are created or that arise out of the interaction of many individuals, but also these collective this collective behavior must be the result of some individual behavior. So that is the reason for methodological individualism. And this is the reason why, even if we are studying macroeconomics, for instance, in economics, we are interested in the micro foundations, in a sense, as a sanity check of these models. Is what we observe on a macro level, can it be explained as being something that can arise on a micro level as well? Okay, with this in mind, why experiments? So on the superficial level, the nice thing about experiments is, of course, you can establish causality without any fancy assumptions. You have a treatment group, you have a control group. If you see a difference, it must be due to the treatment. Now, I give you an example that I think shows this very well. I was a keynote speaker at a conference in China last year, and a young scholar there presented evidence from a machine learning study, and that basically claimed that legal representation in China hurts defense. So a right to legal representation has only been recently introduced in some provinces, but not in others. And now the a priori case for this seems weak, but there are potential reasons. So it could be that prosecutors, judges resent defense lawyers and treat those represented by a lawyer more harshly, or a judge takes the fact that somebody hires a lawyer as a signal of guilt. And so the question is, did the study that the scholar presented settle the question? No, but because there were all kinds of issues in the study. But now the interesting thing was that the senior scholar of constitutional law, I think in China, stood up and said, this all cannot be true, and therefore the empirical method must be wrong. And this is, of course, the most doctrinaire way of looking at things, because the point is, there is an empirical method that allows us to find out what's actually going on. And this is actually, oh, somehow I got a, okay, so what you could do is you can take all the people arrested for theft in a particular court district in which no such right exists. You can randomly assign a lawyer to some of them, and you can compare the outcomes from treated group with those from the untreated group. So that would be a field experiment. So I also had a specific project at my center where we had buy-in from a constitutional judge in a European country where many asylum cases are dealt with by the constitutional court, to actually create a robot clerk and provide clerks with a machine learning generated fact sheet about the applicant, to provide clerks about a machine learning generated fact sheet and a recommendation that's done by the algorithm, and to have a control group where the clerks would be provided with the entire file, as is common. And then to look at the memos written to judges and the decisions. And the idea would be to look at measures like speed, consistency, quality. The project got unfortunately stopped because of opposition from within the court bureaucracy, but you can see that just as a general method, this could be interesting in prosecution law. Now, randomized controlled trials are not always feasible. Even if feasible, they do not tell us much beyond the particular setting we study. And they are not very valuable beyond the setting studied. They settle a practically important question, but it's not valuable for theory development. So I don't want to downplay randomized controlled trials. So for instance, it is practically very important to understand decision processes within the constitutional court. It is, as in Netta's case, the decision by the Supreme Court, does it influence decision making? But does it actually influence every decision, or the media coverage triggered by this decision? And what is the mechanism? Is it individual? Is it through the community? So it's an important question that's answered by a randomized controlled trial. But what you see is there's serious limitations with regard to finding out what the mechanism is. So that was kind of our use case. We looked at these aspirational rules in constitutions, and we wanted to know whether there's a causal relationship between having lots of rights or having aspirational rights and having worse human rights record. And there are, of course, different ideas. But we know that we are there in an area where the field experiment is unavailable, and so we are stuck with vignette studies and lab studies. Now, we did the lab study. We established a couple of propositions in an abstract setting. We established a couple of mechanisms, and we did this in a situation in the lab where actually the situation was endogenously created in the lab. So people were actually working. Everything was payoff relevant. Now, of course, what is missing, and that I think was the criticism of a lot of people, is that is the bit about external validity, and we think that that this could actually be closed. This gap can be closed with vignette studies. So if you give specific scenarios like a stylized Bill of Rights, then if you do a vignette study, you don't get much validity if you ask lay people recruited in MTurk to imagine they are being parliamentarian, civil society leaders or lawyers, but you can get a lot of external validity if you ask parliamentarian, civil society leaders, Supreme Court clerks. So I think that once you have established a result through a lab study or an abstract experiment that you do online, it can actually inform you about the design of a vignette that you would then run on a relevant subject pool. And so all of this together actually is something that is very much in line with Mila and Adam's proposal to triangulate important subjects by using various methods. So I like a metaphor where you basically say, how can you establish that a particular proposition is correct? Well, it is like arguing that, and you can argue with theory that and answer the question, can an animal exist? And if you have a theoretical model that shows there's a consistent theory, then at least there's a theoretical possibility that it exists. The next question is, can it exist in a zoo? And that is something that you can answer in a lab experiment, and then closing the gap to more external validity with a vignette. And then, of course, the next question is, does it exist? And I think that if you can show that it can exist and that it can exist in a zoo, then it's of course more likely that it actually exists. And then if you have observational data that's consistent with the theory, then of course you have many different methods pointing into one direction, and that I think then constructs a relatively convincing argument if you have found something that's the truth. Okay, thank you.
Wonderful. Thank you so much. So there's a lot of different things on the table, probably too many different things, but we do have 10 minutes. So I guess I just want to open it up for people to offer thoughts on any of these topics that have been discussed, ask questions. I know it's a lot, so it's a little bit difficult to respond to. Katerina, yes, go ahead.
So Alex, I'd love to see your asylum paper, and I'm so glad you're quantifying patterns in law journals. I have some issues with the classifications, but I have a bigger objection to the overall, like a core objection to your thesis. I'm all for external validity, but I think it's worth distinguishing between different types of external validity, between having a representative sample, which is something political scientists have cared about for a long time, and psychologists never cared about, and between the external validity of the treatment. And I'm coming back to some of what Neda was saying, and even in a lab, it's possible to have a treatment that's externally valid. So I really liked, you called her study in RCT, which I think it's fair to characterize it that way. But I'm just thinking to old psychology experiments where you just bump some students and call them assholes, and you see if Southern males respond differently, where the treatment is something you might experience in ordinary life. And I think that was, I think that's the best use of psychology studies and those lab mechanisms. I also have some objections about kind of your slide on RCTs as not being the gold standard. I think it's unfair to say for any type of study that they're not important to theory development. I think it would be fair to characterize the bulk of RCTs as testing whether one specific intervention works, but that's not the law literature on RCTs. I don't think we're developed enough to that. I think it'd be fair to say that most RCTs can only test propositions in limited geographic context, but that not even that is true anymore. There's RCTs that, for example, use text messaging, and that can allow you to look at contextual variation. So I guess I'll be writing more in the chat, but in some of your classifications, I think it's fair to say there are studies that separate between observational data and causal inference, and there are degrees of doing that, with experiments being the gold standard. But within this category of experiments, which we're only now seeing in law, kind of whether you give someone a vignette and whether you give it to students or whether you give it to lawmakers, you know, you're still giving people a vignette. And as Adam and Mila said, like, that's not the way they find out information in their day-to-day being. So there's something, I do the same thing, but it's a little bit unrealistic as a treatment, as might be kind of the task you assigned. So to the extent we can work not only on kind of getting a representative subject pool, representative whatever we want it to be, so key decision makers and some, but also the types of treatments that might generate a shift in information, a shift in emotion, we will move the field further.
Okay, great. So I see the next comments are on religions and constraint. Ross has a question, but I want to see if anybody wants to respond on this topic. Otherwise, we're constantly jumping back and forth. I mean, to me, one question is like, so a number of people have said now that in a lab, you can potentially do better in terms of making it resemble constitutional settings more closely, but I haven't heard anybody say how, right? Like, and so as somebody who doesn't do this, it seems like, for example, in Adi's and Alex's study, they do a number of things. They keep the payoff the same regardless of performance, like civil servants. They give the money to a charity, right? There's like some things they do, but then I guess people get kind of hung up on the counting tables. So instead they should be arresting people or something like that. I don't know. I mean, I guess like I'd love to, I mean, yeah, just question I have. I guess maybe Alex, you want to respond, but I also.
Well, I think the small thing that I want to say is I don't want to at all dispute that you know, having rich context is something interesting to study. The problem with rich context, however, is that in the end it's extremely difficult to know what actually drives the effect. So if you have a very abstract setting where, let's say, the interaction arises out of the setting. Yeah. So, for instance, the classic situation would be that, you know, in a vignette you tell somebody, imagine you've made a promise, whereas in an abstract lab study you create a situation in which people in the lab make a promise and then act accordingly, or maybe renege on the promise, or whatever. So I think there are certain advantages to this, because in the end you then, you know, have results or statements that are that arise in an abstract setting and not in a setting that you have highly specified. Yeah? So in some way they are probably more generalizable. Now, of course, then the question is, do they also work in the specific situation or in some of the specific situations that you are interested in? But I think this is a complementary question. So I think that's probably what I wanted to kind of point out by saying, I think that the lab experiment is a very good first step. And then the vignette study kind of can close often a certain gap to this external validity concern. And then I think that is the last thing that maybe I wanted to point out. I think that giving a vignette study to students where you say, imagine you're a parliamentarian, imagine that you are, you know, a lawyer, imagine that you are a Supreme Court clerk, is not as effective as giving a highly contextualized study to people who are actually in this position. Because usually people who are in responding to vignette studies, and I was, as an economist, always for a long time, I was very dismissive about vignette studies because they were not incentivized and so on. But I've now found that, you know, if you ask the students vignette studies, they usually answer very, very similar to how they actually play in the lab. So if you give people something that's close to their experience, then it's not as if they give you the wrong answers. They try hard to actually, you know, give you the probably a correct answer. So that's I think what I want to say, that I think there is a certain advantage to the abstractness of the lab experiment, and you can close the gap to the external validity through the vignette study. That's what I think you can do.
Great. So it's now morning in Australia, so I'm excited that Ross is here to bring some energy to the conversation, because we've been at this for some while. So go ahead, Ross.
So I'll say my more substantive remarks when we start our panel, but thank you for the opportunity. It's great. So I guess what I wanted to ask was the point that links Yvonne's reference to religion in Russia and Mark's point about constraint, and whether there's a way of thinking about this empirically, which is, you know, constitutional rights don't need to matter when the government has an interest in complying with them, right? So arguably, Putin needs the Orthodox Church in Russia. It's a part of his support base. You don't need rights to religious freedom if the people in power have a strong interest in protecting the relevant rights and interests. So this is a version, right, of, you know, the Eric Posner, Jack Goldsmith point about customary international law. They say it's not law if people have a strong interest to do it anyway. And I guess, you know, Mark Graeber's point about constraint is, you know, Putin protecting the Orthodox Church is not something we would expect law to matter in relation to or to be constrained. Putin protecting the press is, right? So even though it's a really lovely opening case study or vignette, it's sort of presses hard on the when would we expect rights to matter. And I wonder whether there's actually a way of thinking about kind of bifurcating some of the examples into this is when we think law really should matter and should constrain or bind, versus law is just an expression of what we would expect political interest convergence to lead to anyway. And, you know, Rich and I are going to talk a bit about this in our remarks for how you might think about that. But it seemed to me that if one connects Mark and Yvonne, Putin and religion is not a case where one would have expected law to constrain, and therefore it's not a good test case for whether it matters.
Okay, and Mark asked me to respond briefly.
Just briefly, one thing law may do, I said, is empower. So in fact, to take a simple example, most Republicans in 1860 did not believe they had the power to interfere with slavery in former Confederate states. What law did was empower them. And I simply want to highlight this is a function of rights, that often rights don't simply come as a form of restraint on government. Government don't do this. But in the Constitution of the United States, rights come as federal government. You have the power to ensure localities respect these rights. And as a number of people have written here, another thing, we don't separate rights and structures, that quite frequently a constitutional reform has both altering the structures so the government becomes more committed to the right.
Okay.
We should probably break, but I would just wanted to say one thing on the Russia point, since we've been talking about it concretely, which is I agree that the treatment of the Russian Orthodox Church isn't a good case study for the right to religion, purely. But, you know, a lot of what we focus on is the treatment of Scientologists and Mormons and all of these weird groups that Putin had every incentive to crack down on and desperately wanted to. It's those groups that were able to use the rights in an effective way that I think makes the case. Because I agree, he wants the Orthodox Church on his side, and it takes the interplay to get at it.
It's really that interplay, right? So these measures are targeted mainly at the Scientologists and all these foreign groups that enter the country, but they also hurt the Russian Orthodox Church. So the Russian Orthodox Church leads the pushing back, and then in the process of protecting its interest, also protect religious freedom more broadly for these smaller groups, right? I do think Yvonne has a good point. Like, do we have the best case study there, considering like is this a fact mainly driven by the fact that the Russian Orthodox Church was also pushing back, right? Could smaller groups do that on their own, or would they have to team up together? I mean, that was one thing that people in Russia kept telling us, like we're working across different religious groups, and that really helps. Not the Scientologists so much, but the small Protestant groups and others. So I mean, yes, but it's, yeah, I guess that's
And it depends on the strategy of the group, right? Because the strategy of the Orthodox Church could have been to pick off the Orthodox Church and throw the smaller religions under the bus. And it's actually contingent on their strategy to find that it works.
Yes.
We should take our 15-minute break, although we'll leave the Zoom on for anyone that wants to keep talking, but just in case anyone wants to play.